Next question, a little bit more specific to litigation. So this one is, we have a Daubert hearing in a few weeks. Should I follow your hearing prep that's in the pleadings in motion section, or is it more like a pretrial conference? The other paralegals at the firm said it's more like a mini trial, and now I have no idea what to expect. Any advice that would be greatly appreciated. Now I'm laughing because that's true, right? You're like, okay, was it this? But these paralegals said this. First of all, for those that don't know, a Daubert hearing is where the court, the judge, is going to hear evidence of whether or not the expert is qualified to testify. And it's usually only about scientific, like mathematical type, statistical experts, those types of experts who are going to testify about a method that they used to come up with their expert witness testimony. And now you might be asking, if you were the person who asked that question, you might be asking, well, why didn't you teach that in the boot camp, Anne? Because 90% of the people who ever take the litigation boot camp will never go to that type of hearing. They're only in very large cases with very expensive expert witnesses. A lot of cases have expert witnesses, but this is different. This is where it's a method that they're using that the other side wants to question the validity of, so that maybe, hopefully, the judge might exclude some or all of that expert witness testimony. So that's why. All right, that being said, first, I would suggest go to Rule 702. You know me, I always send you to the rules. Go to Rule 702, Federal Rule of Evidence 702, and read that, know that like the back of your hand. But here's the thing. You don't need to know what they're going to object to and that. You just need to know generally, right? My advice is to immediately, no matter where you are in the course right now, skip down to Module 5 and do the trial prep, because the other paralegals in your office are right. This is not like a pretrial conference. This is not getting ready for a regular old hearing. This is essentially a mini trial. The Daubert hearing I remember the most was the case that I worked on. It was an antitrust case. It was price fixing in the carpet industry, and the case lasted for years. And I talk about that case a lot in the course. I don't know that I tell that detail, but that's that case. And the Daubert hearing that we went to was 5 days long. There are some trials that don't last 5 days. They were long days, and it was a lot of working with the litigation technology, the trial tech team. So at the time it was, I can't remember, but they were using Trial Director. It was before we had the easier apps and stuff to use. They ran that entirely. I didn't have to do any of that. I was just in the courtroom supporting the attorneys with the exhibits and things that they were going to be presenting to the experts, and I was managing the experts and all that, and I was busy all day long and not even handling the electronic aspect of it. So go through the trial prep checklist, go through all of Module 5. If you have time, hopefully take your time going through it, download all the checklists, and treat it as if, so there's going to be expert witnesses testifying for your team. I don't know which side filed it, but then what's going to happen is, so those expert witnesses are going to be on direct exam, just like you would have at trial. Then they're going to be on cross-exam, just like you'd have at trial. Then the other side is going to put up their expert witnesses saying exactly why your expert should be excluded. Then they're going to be cross-examined. So it's going to be like a trial with many witnesses. And sometimes the experts they bring in might not even be experts that are specifically working on the case. They could be brought in just to be an expert on why this Daubert hearing should exclude that evidence. So yes, very good. See, the thing is, the reason why they do that, I think, is it could impact settlement. it doesn't happen a lot where the expert testimony completely gets stricken, but sometimes they will take out small chunks and say, the expert can testify, but not about this part or not about that part. And so it's very important because it could lead to potentially maybe the other side decides how, because of the result of that hearing, we're going to settle the case. Or they could decide their case is even stronger because the judge agrees that that expert method is valid. Now, here's the other thing I would caution. In every one that I've ever attended, now I shouldn't say that because it's not like I've attended a bunch of them, but there were 4 that I attended. That one was the longest one, but in every single one, what happened from the moment of the Daubert hearing forward, nothing gets done really because the trial's not set yet. And you've got some time if you want to be able to work on it, but usually that's your time to jump over and catch up on your other cases because those rulings can take a long time. Like I think that one that was the 5-day, I think that took like 3 or 4 months before that came in. And so nobody's going to trial until that, because that if that testimony gets stricken, then it's going to change the trial.